Hello viewers, welcome back. This is the third installment of the first series of lecture on Cr.P.C. Previously, we have covered few lectures on definition clauses, and in this video also we'll cover the rest of the definitions, and we'll try to finish the first chapter in this video itself. And in this video we'll discuss few remaining definitions. There are 3 to 4 definitions that are to be understood and discussed, and the first of them is the definition of complaint that is mentioned under section 2D CRPC. And the next few minutes we are going to discuss the ambit of section 2D read with section 200 of CRPC that talks about complaints to magistrate. Although elaborately we'll discuss sections 200 to 203 in our further lectures, because that is a different chapter in itself. And we'll also discuss here the difference between the complaint and the FIR, because these two words are often used interchangeably, which actually is not a right thing. So let's give you an example to discuss to make you understand the concept of complaint and FIR. So let's suppose an offense has been committed against you under section 420 IPC, which talks about cheating and dishonestly inducing delivery of property, and it is a cognizable offense, so, which means that a police officer can arrest you without the warrant, and it is mandatory for police officers to register the FIR. To register the FIR without any orders of the magistrate or anything like that. So, so, offense has been committed against you under this section, and you go to a police station and you request the police officer to register the FIR, and he refuses to do so. But he refuses to do so rather. So, what remedy does, as an aggrieved person, do you have now? So one smaller remedy is given under section 154, that is to approach the superior officers of police authorities and ask them to register the FIR or direct their subordinates to do so. But if there also you do not get any relief, then usually what happens is that we file an application under section 156 clause 3 CRPC, and the purpose of that application is to seek the remedy from the court and for direction again to the police officer to file the FIR uh, in case a prima facie cognizable offense is made. Um, but usually, what happens nowadays is, along with the said application, a complaint under Section 200 is also filed by the lawyers in such cases where the police authorities refuses to register the FIR. So the purpose of both these applications, the first application is simply to direct the police officer to register the FIR, but the purpose of filing the 200 complaint is to ask the court to directly take the cognizance of the matter based out of the complaint, which is taken under section 190 clause 1 subclause A of CRPC. So this particular complaint under 200 CRPC is what we are concerned with right now. So the content of those allegations forms the crux of the definition under section 2D only. So in that particular complaint, what we inform the court is that in what manner the offense has been committed against you, who has committed the offense, the date, time, the manner, everything is put into that application, and the particular prayer is asked for taking the cognizance of the offense. And after and the court, after going through the complaint, if it deems fit, then it can take the cognizance directly, or if it does not deem fit at that moment to directly take the cognizance, it can also ask the police officer to firstly investigate the case, and if after investigation if a plausible case is made out, then the competent courts can take the cognizance. So that is the procedure that is given at 200, but we'll definitely elaborate on it in our further videos, and we'll discuss that particular chapter. So That's what complaint is all about. That's what all section 2D tells you, that there is that there needs to be a written or oral allegation against the accused person, which can be known or unknown to the victim, and we ask, and based out of that, based on those allegations, we ask the court to take appropriate action. Though that appropriate action can be of taking cognizance or not to take cognizance, that depends totally upon the discretion of the court. And also the court can also direct the police officer to investigate the case, as is done under 156. The other important limb of section 2D is its explanation. So before that, sorry, section 2D also says that under the ambit of complaint, police report is not considered to be within its ambit. So why? So what is the reason behind this? So the simple reason behind this is that the police report is the culmination of the investigation that is carried on the basis of the FIR that is registered. But in the complaint, on the other hand, in the complaint, the individual approaches the court to take the appropriate action and not does not approach to the police officers. So that is the difference between complaint and FIR. That is why complaint and FIR are two separate things, and it categorically been stated in the definition that complaint will not include the police report, because in police report the person directly goes to police officer and not to the courts. And also, and the other thing which is important to be understood in this aspect is, yes, the next limb that I was talking about is the explanation of section 2D. So the explanation of section 2D says that is actually an exception to the its main definition, to the extent, excuse me, that its explanation says that, for example, I'll give you an example, and then you will be able to understand it better. For example, a police officer, an investigating officer, has started an investigation on a cognizable offense, and after the investigation is completed, it was found out that that particular cognizable offense was actually not made, but a inferior offense or a lesser offense was made that was non-cognizable in nature. So when this particular thing happens, and in this case, when the police report is filed based out of that lesser offense which is non-cognizable in nature, and that particular police report is deemed to be a complaint, and that police officer is deemed to be a complainant. So the feature important feature before any police report can be deemed to be a complaint is that that police report should be or should restrict itself with a non-cognizable case only, because if it will contain a cognizable case, police officer will not require any orders from the magistrate to do the investigation. It can do it on its own, as it is given in section 156. But since in non-cognizable cases, police cannot conduct the investigation on its own without the orders of magistrate. Therefore, any report which is filed by the police where only non-cognizable offense is made, there the police has to file that report before the court and seek the orders from the magistrate under section 159 to conduct the investigation uh, 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 based on that report. So that is the reason that only a police report based out of a non-cognizable offense is deemed to be a complaint, and not any report which contains any cognizable offense. So this was all about section 2D complaint, and the other important relevant definitions of CRPC are mentioned under 2G and 2H. 2G talks about inquiry and 2H talks about investigation. So what does inquiry mean? So inquiry under CRPC means any scope of due diligence or work carried out by the court after the investigation is completed and before the trial is commenced. That is after the filing of final report under 173 and before the stage of framing of charge. So what does this due diligence comprises of? So it basically comprises of supplying the necessary documents to the accused person. That comprises of your final report and the uh, uh, documents annexed with the final report and relied upon by the prosecution, that is compulsorily to be given to the accused, and it is to be and this particular exercise is monitored by the court, that all the documents are properly given to the accused person so that he can also make his case in a better manner and the principle of natural justice is not compromised with. So that is the scope of inquiry which is given in under section 2G. And 2H talks about investigation. Now, investigation includes all those activities which the police, the investigating officer, performs during the course of investigation. That includes collecting documentary evidences, collection of statements of the witnesses of the accused, collecting ocular ocular evidences, etc. The forensic evidences. So anything which forms part of the anything which forms part of the final report, that is that the investigating officer uh, actually gets from its investigation is comes under the ambit of investigation as mentioned under 2H. So investigation is actually linked with the police officers, that is the executive, and the inquiry is linked with the courts, that is your judicial branch. So you can understand it in this manner, that inquiry is related to courts and investigation is related only to police officers and not to courts. And the next definition, which is important, is of warrants case and summons case. So warrant case is mentioned under under 2X, and your summons case is mentioned under, I think, 2W. Yes. So it is very simply defined that warrant cases are all those cases where the amount of imprisonment, the extent of imprisonment is of 2 years or more, and of death or imprisonment for life. And all the other offences, apart from these offences mentioned, are within the ambit of summons cases. So any offence that attacks the imprisonment of less than 2 years of imprisonment are summons cases. So the last important definition to be covered is of victim, which is mentioned under section 2WA of CRPC. This particular definition was added to the list of the definitions by way of amendment in 2009. So this question can come in preliminary examination of judicial services, that when the definition of victim was inserted into CRPC, the answer is 2009 amendment. So, victim includes, so who is a victim? So, in criminal law, there are there are victim and there is an accused. A victim is a person against whom crime is committed, and the accused is the person who commits the crime against the victim. So, excuse me. So, the victim will be a person who suffers any loss or any injury to his life out of the acts or omissions committed by the accused persons. And the second limb of this definition says that victim also includes the legal heir and guardian of the victims. So the purpose of including and these two persons or entities or anything in the definition of victim is because if in case the victim is deceased, then somebody should be there to represent the victim in the course of the proceedings or trial. So therefore, the legal guardian and legal heir can come in place of victim and can represent him or her after the victim is himself or herself deceased. So that is the purposive interpretation of adding the legal guardian and heir in the definition of victims. So that was, I think, all from the definition clauses, and that also concludes the first chapter of the CRPC. And hope you all have liked this entire discussion, these three videos, and if there is any scope of correction or anything which you want me to advise, you can please put it in the comment section so that I can include in my videos. If there is any problem related to sound or anything, please inform me about that in the comment section. I'll be really looking forward to that. And I also do have the notes on case laws related to almost each of the sections, but which I'll be sharing with you all in a course of time. I'll share it in the PDF form in the video itself, and so that you guys do not have to do any much labor, put into any labor in finding the case laws of the sections. So I'll do it for you, and I'll give it to you in the PDF form, and our next video will also come maybe by tomorrow, but not on CRPC, because I'd also would like to make videos on civil laws also alongside. Uh, so that was all from the first chapter of CRPC, and I'll continue making the videos. And next videos will probably come on maybe Evidence Act or on CPC. I'll look into it, and thank you again for watching the video, and please again ask others to subscribe and please share the video.